My name is Harvey Swan and I'm acting as representative for Barry and Wendy Greene in this conciliation. The Registrar for Births, Deaths and Marriages failed to accord procedural fairness to Barry and Wendy Greene when taking the decision to name their newborn child. We seek that the Registrar provide an opportunity to the Greenes to comment on any adverse information relied on and remake the decision in light of those comments. Barry and Wendy Greene are proud new parents of a baby girl. Okay, they decided to call her Bendy Enid Greene, and Bendy being a combination of both their first names, Barry and Wendy. The Greenes applied to register the name in compliance with their responsibility pursuant to Section 81A of the Births, Deaths and Marriages Registration Act 2003, which I'll refer to as the Act from now on. On the 10th of March, the Greenes were sent an informal email by Mr. Burrito, the Assistant Deputy under Registrar of Names. In that email, he essentially refused to register the first name, Bendy. It was in his opinion that it was a ridiculous name, and the Greenes responded in kind by alleging that Mr. Burrito's name was ridiculous. On the 2nd of April, the delegate for the Registrar of Births, Deaths and Marriages formally wrote to the Greenes and refused to register the first name, Bendy, on the grounds that it was a prohibited name within the meaning of Schedule 2 of the Act. According to the delegate, the name was contrary to the public interest as it would expose the child to ridicule, and the name is also an offensive word in an Himalayan language. The delegate proposed a new name to the Greenes and gave them 14 days to comment. However, neither of the relevant reports were provided to the Greenes, and therefore they have not been accorded procedural fairness. The Greenes are understandably dissatisfied with this decision, and pursuant to Section 49 of the Act, have the right to dispute the decision in Queensland's civil and administrative tribunals review jurisdiction. Before making my substantive submissions, I'd like to deal with a couple of preliminary issues that give rise to the duty to accord procedural fairness in the circumstances. In Minister for Immigration and Border Protection and WZARH, Justices Kiefel, Bell and Keane provided that in the absence of clear contrary legislative intention, an administrative decision maker must accord procedural fairness to those affected by his decision. The Act conferring the power makes no mention of procedural fairness, and therefore the common law will imply that duty that the delegate afforded to the Greenes in naming the child. Further, the exercise of the power affects the interests of the Greenes. The Greenes' interest in naming the child has both a reputational basis as well as a legislative one. In regard to reputation, Annetts and McCann, the majority held that a parent's interest includes the protection of a child's reputation. What is a name if not the foundation of reputation? In Kyoto and West, Justice Brennan provided that when a legislator creates a regime for the regulation of social interests, such as naming a child, although it may not amount to a legal interest, it should still be accorded the protection of procedural fairness. Therefore, the responsibility given to the Greenes by Section 81A of the Act, as well as the reputational basis, gives the Greenes standing in this matter. Turning to my substantive submission, I intend to break it down into 2 points. First, that the delegate should have given the Greenes the opportunity to provide written comments on the adverse reports. And second, had they been given that opportunity to comment, there is a realistic possibility that the decision could have been made differently. Turning to the first point, the Greenes accept that not every adverse piece of information that a decision maker relies on attracts the opportunity to comment. However, the significance that the delegate placed on the reports in finding that the name is against public policy and is therefore prohibited attracts the opportunity to comment on the substance of that adverse information. In Kyoto and West, Justice Brennan provided that in an ordinary case, the opportunity should be given to deal with adverse information that is credible, relevant, and significant. The repository of power cannot endeavour to shut down information of this kind, as it creates a real risk of prejudice, and it is unfair to deny a person whose interests are likely to be affected by the decision an opportunity to deal with that information. The reports are apparently credible, relevant, and significant to the decision of naming the child, There is nothing in the circumstances of this case, nor in the administrative framework of the Act, which would have made it unreasonable to have given the Greens the opportunity to comment on those reports. Therefore, the delegate has breached their duty to accord procedural fairness when coming to the decision to name the Greens child. Turning to my second point, the materiality of the breach is of such a nature that had the opportunity been given to the Greens, there is a realistic possibility that the decision could have been different. It cannot be contested that the basis of the decision was the reports. The majority in the recent High Court decision of Nathanson and Minister of Home Affairs held that it is necessary to consider whether the decision that was made could have been different had the relevant condition been applied. That is, had the Greens been given an opportunity to comment, could there be a realistic possibility of a different outcome? The question is not answered on the balance of probabilities, but it's on the standard of reasonable conjecture. The standard of reasonable conjecture is undemanding, and it recognises that the fundamental purpose of procedural fairness is to afford an opportunity to raise relevant matters that are not already obvious. It follows from this that as a matter of reasonable conjecture, had the Greens been given an opportunity to see the reports that raise matters which are not already obvious, such as an offensive word in a not commonly spoken language, there is a realistic possibility that the decision-making process could have resulted in a different outcome. Aside from the substantive submission, there is also a tertiary point I'd like to make. That is the potential for the delegate to have had an apprehension of bias. It's no secret that Mr. Burrito and the Greens had a short email exchange which could be described as hostile, and that Mr. Burrito's report was one of the reports that the delegate relied on. Considering that the report was based on one hostile email exchange, there is certainly a potential for bias. It would be procedurally fair that the Greens are provided with the reports in order to assure them that the decision maker brought an impartial mind when making the decision. It is for these reasons that the Greens should be given the opportunity to see the reports, provide written comments on them, and the Registrar remake the decision in light of those written comments. That concludes the opening statement on behalf of Barry and Wendy Greene.